On the way out the door, Joe Biden's Department of Justice decided to leave a little gift, for the Second Amendment community by arguing that indeed there is sensitive places everywhere. And as you know, sensitive places are government-mandated gun-free zones. Let's hear what Joe Biden's Department of Justice had to say on the way out the door, because the arguments they made in favor of gun-free zones is arguments we're going to have to contend with going forward, including ultimately before the United States Supreme Court just down the road. Let's get into all this right now. Hey folks, I'm Mark Smith, host of the Four Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in the 2025 Gun News Awards. Thank you for your support and thank you for watching. Okay folks, let's get right into this. The Firearms Policy Coalition versus Garland case, which is going to have to change its name real soon because thank God, thank you, Lord, Merrick Garland is no longer the Attorney General of the United States. So down there in the United States District Court for the Northern District of Texas, the federal court down there, we have a major fight over quote-unquote sensitive places. And I don't mean sensitive places in a positive way. I'm talking about government-mandated gun-free zones. That's right, as you know, there are references to sensitive places. This is what the anti-gunners call them. There are references to this in the U.S. Supreme Court opinions. And what they really are is, again, government-mandated gun-free zones. And the question is, when, if ever, are government-mandated gun-free zones consistent with the United States Constitution, specifically with the Second Amendment's right to keep and bear arms? Well, there's a major fight going on down there in Texas dealing with a specific type of quote-unquote sensitive place. That is whether or not you can bring a firearm in to the United States Post Office when you go there. As you know, many post offices around the country don't even have their own buildings. Many post offices have little shops or little parts of malls or strip malls or whatever it is. They're all over the place. And the bottom line is that under federal law right now, including the regulations, you are not legally allowed to bring a firearm into a post office, even though there's really no rationale for doing so. And as you know, there used to be a sort of a kind of joke, morbidity kind of concept of going postal, because for a while there were postal workers that would engage in shootings of their fellow employees and colleagues, and you had a phrase going postal that I think has fallen out of favor for good reason. Thank God it has. Nevertheless, the idea that you could walk into a post office and you would have to leave your gun in the car or at home because you're not allowed to defend yourself for no reason other than the fact the federal government has simply said, no guns allowed in post offices. Well, are these laws and regulations that ban guns in post office constitutional under the Second Amendment? The answer is undeniably, in my view, no. So let's break it down. Specifically, though, let's talk about the arguments advanced by Merrick Garland's Department of Justice on the way out the door. And I think this is a particularly important brief, which I'm going to put a link to in the description of this video. Why do I say this is a particularly important brief? Because on the way out the door, as the Biden administration was going bye, and the Trump administration was coming in, the reality is that Joe Biden was trying to do all sorts of things that would mess up the conservative movement, the Make America Great Again movement, and the Donald Trump administration. And one of the ways is to take these crazy positions against guns in various federal lawsuits, including this one down there in Texas, the Firearms Policy Coalition versus Merrick Garland. So let's just talk about some of the arguments that the Department of Justice under Merrick Garland made on the way out the door. The first is, and this is quite interesting, they basically say that, ready for this, folks? You're not going to believe this. They literally argue that NYSRPA versus Bruin, the 2022 Supreme Court case, does not apply. Hear what I just said? Does not apply. And the Bruin methodology of text first, burden shifting to the government, historical analysis, that methodology that we're all very familiar with does not apply if you're in a fight over quote-unquote sensitive places or government-mandated gun-free zones. Here is what Merrick Garland's Department of Justice said on the way out the door about Bruin and sensitive place litigation. The Second Amendment plaintiffs paint Bruin, the case, as imposing a uniform test on all Second Amendment cases. That cannot be squared with the opinion itself. For starters, the court assumes that disputes regarding the lawfulness of sensitive place prohibitions are settled, which hardly connotes, and indeed would seem antithetical to, a one-size-fits-all mode of analysis. Rather, the case Bruin is best read to reaffirm, as McDonald did before it, Heller's admonition that those regulations are presumptively valid. If the court, meaning the Supreme Court, if the Supreme Court wished to displace the sensitive places doctrine, it would have done so explicitly. Or it could simply have announced the history and tradition test and left it at that. The only plausible reason to call out the sensitive places for the third time was to signal that they are subject to a different mode of analysis, namely one that begins with the presumption that restrictions are lawful, citing to Heller. Okay, this is crazy, literally crazy talk. NYSRPA versus Bruin, as well as Heller, are binding Supreme Court precedent on the lower courts. There is only one mode of analysis, only one method. You start with the text of the Second Amendment. The right of the people to keep and bear arms shall not be infringed. Where you're dealing with a ban of guns, meaning you can't bring guns into the post office, and it's a law. Guess what? It obviously infringes your ability to bear arms because, as the Supreme Court has repeatedly said, the right to keep means the right to possess. The right to bear means the right to carry in public for self-defense purposes, right? So the right to keep and bear arms is obviously infringed because it's being interfered with or hindered by a ban that says you cannot bring a gun into the post office. So the text of the Second Amendment is obviously implicated. It obviously gets pulled in. What happens? You know what happens. The burden shifts to the government to show that notwithstanding the violation of the text of the Second Amendment, there is some sort of historical-based exception, not just based on airy-fairy history, like period undergarments in the 19th century or something like that. No, it's a particular type of history that the Supreme Court cares about, which makes sense. Specifically, the history is, are there laws on the books that were actually enforced at the time of the founding that were analogous to the modern-day gun control law that the anti-gunners today are trying to enforce against us and argue that they are consistent with the Second Amendment. There is no alternative mode or method of analysis under the Second Amendment other than the text first, burden shifting to the government, and then historical analysis part. That is the test for all Second Amendment cases. The reason why Bruin talked about sensitive places and discussed it in the context of the Bruin case was because New York, listen carefully, folks, this makes you smarter than the lawyers of the Department of Justice, which I know I can do when it comes to the Second Amendment. Probably other things too, but set that issue aside. In Bruin, one of New York's arguments was that they could ban guns, or at least only allow a few special people to carry guns in New York City and New York State. They could do that because essentially they could declare all of New York a sensitive place. And the Supreme Court, in rebutting and rejecting that argument made by the state of New York, talked about quote-unquote sensitive places. In that context, it specifically said you cannot declare the island of Manhattan a sensitive place simply because there's a lot of people there and there presumptively is law enforcement floating around with the NYPD. So that is why sensitive places came up. It wasn't that they were carving sensitive places out of the methodology. It was referring to rejecting the gun controller argument in the Bruin case by the state of New York. So that goes nowhere here. There's only one methodology of Second Amendment cases, and it is the Bruin methodology, which is really the Heller-Bruin methodology of text and then history. So this argument by the Department of Justice, I do not think will fly. Now, the second argument that DOJ advances here is they try to argue that the word presumptively has some significance here and that the presumption is in favor of the government in sensitive places cases and not in favor of the Second Amendment community, and that is simply wrong. Let me give you their argument, and then we're going to break it down. I'll make it very easy for you to refute. Not a heavy lift here, but let's see what they say. This is what Merrick Garland's DOJ said on the way out the door. At times, the Second Amendment plaintiffs argue that the word presumptively shifts the burden from one party to another. Citing to Bruin requires that courts first assess whether the Second Amendment's text covers an individual's conduct, and if so, the Constitution presumptively protects that conduct. But then the DOJ goes on to say, but when the word presumptively might require plaintiffs to offer even modest support for the historical theory, they contend it overreads the word to infer any such burden shifting. In such circumstances, according to the DOJ, the Second Amendment plaintiffs demote presumptively lawful to a mere marker that signals the court's expectation about future cases. Okay, folks, this is not a heavy lift. I want to give you two rules. I'm going to digress briefly, but I'm going to give you two bits of advice that I learned my first year of law school from the dean of NYU Law School, where I attended. two critical things about the law. Number one is that any word can mean anything I want it to mean if I define it, which means when you read a contract or statute, you need to read carefully how that particular word is used. So any word can mean anything if you give me the right to define it. The second corollary concept there is this, that the exact same word can mean two different things in two different contexts. Okay? The example I like to give is the word bank. If I write a sentence that says, you cannot bring a gun into the bank, or you cannot bring a gun onto the bank's property, the word bank could mean a river bank, or it can mean a financial institution. Do you see? So the same word can mean different things depending on how you define it. Now, with that said, let's turn back to this argument by the Department of Justice about the word presumptively. It is crystal clear if you read the Bruin case. On several occasions, they literally say that once a modern-day gun control law is implicated by the text of the Second Amendment, sometimes they call it when the plaintiff's proposed conduct is implicated by the text of the Second Amendment. It's really the same concept for your purposes. The burden shifts, you see what I'm saying? The burden shifts to the government to show there's a historical analog exceptions to that. And here's where the court says, the presumption is that once the text of the Second Amendment is implicated by a modern-day gun control law, the presumption is the government's going to lose, that law is unconstitutional. And then the government bears the burden to overcome that presumption. They have the burden to overcome that presumption to show historically some sort of modern-day gun control law was analogous to a historical law or set of laws that would justify today's modern-day gun control law. The example I like to give is laws against using guns to commit murder, right? We know that the text of the Second Amendment protects your ability to use guns. But if you use a gun to commit cold-blooded murder, well, we know that's not allowed as a matter of historical practice because there's lots of historical regulations on the books at the time of the founding that you cannot use a gun or any weapon for that matter to commit cold-blooded murder. So even though using a firearm might implicate the text of the Second Amendment at the first blush, when you look at the history of it, the government would be able to overcome that presumption and say that a law that bans the use of guns to commit murder is constitutional and consistent with the Second Amendment. But again, you have to use the history, and the burden is on the government to show that history overcomes the text, and thus the presumption of unconstitutionality applies, and it's up to the government to overcome it. Now, what DOJ is doing here is they're trying to say, in a couple different contexts of Heller and Bruin, there's references to say that we're presuming or we're assuming that these laws are constitutional. But again, and they're talking about that in the context of, let's say, sensitive places. Now, what they're really saying is that for the purposes of writing this opinion to talk about it, generally, we're assuming or presuming that laws that ban guns in certain places, like courthouses and legislative chambers and polling places, would be constitutional, that guns that ban laws there would be okay. If you did it today, because historically that was done. They're presuming that to be the case. Now, they're not finding it. They're not shifting the burden or anything like that. They're just saying for the purposes of our writing, when we discuss in the context of dicta, because you didn't have to decide this specifically to rule against New York, but in light of this, they were just simply saying, look, we're presuming or assuming this is to be the case, but nothing about that kind of language in discussing history generally overcomes the very precise holding and clear directive by the U.S. Supreme Court that when the text is implicated, the burden shifts to the government, and relatedly, the presumption is, or that law, the modern-day gun control law, is presumptively unconstitutional. But here DOJ is trying to blend the concept of presumption by using the word presumed in other contexts of the case to try to override the central holding of Bruin, and that is simply not going to fly. And in many respects, it's disingenuous to even make that argument, but that's what DOJ is doing here. The other interesting point that DOJ makes here is they try to say, look, there's something crazy about the Second Amendment argument here, about what constitutes a sensitive place and what is allowed to be a sensitive place consistent with the Second Amendment. The Second Amendment plaintiffs here in the Firearms Policy Coalition are arguing, and I think correctly so, that the only way a location today in modern American life can be a sensitive place, government-mandated gun-free zone, is if the government actually steps up and provides comprehensive security the kind of security we see at airports when you go through the TSA. You got metal detectors that prevent guns from being brought in. And you've got people with firearms and other weapons, including U.S. Marshals, available after you go through those metal detectors. The point is that's comprehensive security. And in that context, you can ban guns. Same with federal courthouses. Courthouses have metal detectors and men with guns and women with guns that will protect you. The idea being that if the government's willing to step up and take over your security for you with guns and metal detectors and provide this comprehensive security, they're really taking on the onus or burden of defending you, well, then they can declare that a sensitive place. But they cannot declare something a sensitive place and ban guns just by waving a magic wand or sticking up a sign. That is not adequate. It's simply not good enough. And by the way, the history proffered by the Firearms Policy Coalition here was quite good. It showed there was security at the courthouses. Remember, there's 3 places the Supreme Court has said are sensitive. You can ban guns: courthouses, polling places, and legislative chambers. And in all 3 instances, there's ample history that there were indeed either bailiffs, sheriffs, sergeant-at-arms, deputy sheriffs, whatever, there to protect the proceedings as they were ongoing in those locations. So by analogy, it would seem to me that modern day places have to be protected with comprehensive security, and all the other theories that we've talked about in prior videos are simply not adequate to explain and justify in modern life what would be a quote-unquote sensitive place other than comprehensive security. But with that said, DOJ tries to make this very cute argument, and what they specifically say is that the theory cannot hold true when it comes to post offices, which is what this case is about here, because they're saying that, look, one day there may be comprehensive security on Monday, Tuesday, and Wednesday, but then if the security officer or the metal detector guy doesn't show up for work on Thursday and Friday, well, then it's no longer a sensitive place. And the answer is that's obviously correct. And it's not a big deal to think about that sensitive places can sometimes move. And what do I mean by this? Let's take the most basic thing. How many of you have ever been to or seen on TV a presidential candidate go to a local high school or go to a local theater or to a concert venue or to a diner, a restaurant, whatever it is, right? You know, Donald Trump goes out there today and wants to talk to a local diner. Well, 99.9% of the time, that local diner is, guns are allowed, no big deal. But if the president shows up in that diner with Secret Service with all that comprehensive security that it's going to be brought along, guess what? That becomes temporarily a quote-unquote sensitive place because they will keep all the guns out, and yet they will provide guns to protect the people there from bad people doing bad things to good people. So it's not a big deal if the post office can provide comprehensive security on Monday, Tuesday, and Wednesday, maybe they can ban guns there at that particular post office. But if there's not comprehensive security on Thursday and Friday, then guess what? Hey, you can't ban guns because, again, it's not enough simply to pass a law or a regulation that says no guns are allowed. Labeling something a sensitive place doesn't mean it's consistent with the Constitution any more than if I just pass a law that labels a .22 caliber, lever action rifle a machine gun. A legislature could call that a machine gun and say that you're violating the NFA and you go to prison if you have a .22 caliber long rifle with a lever action. But the courts would be able to legally look beyond that to the actual item to see if it's really a machine gun and say it's obviously not a machine gun and therefore it's not a crime to possess this, for example. So again, it is not unusual for there to be actual analysis on a case-by-case basis. And again, if they want it to be comprehensive security, they can probably consistently, with the Second Amendment, ban guns in a particular place for a particular time. But unless they provide that comprehensive security, they're not going to be able to do it because there's no other theory that explains how you would allow guns to be banned at TSA and these other locations, but not everywhere. So this, I think, is the best theory that I've heard, and DOJ is trying to knock it down. We'll see what the court does. I think there's a good chance that the Firearms Policy Coalition is going to win this case down there in Texas because, again, there have been instances before where the post office has been declared you can't ban guns there, including a case in Florida. So there you have it, folks. Hope you learned something here today at the Four Boxes Diner. Make sure you subscribe both to Rumble and YouTube. Don't forget to follow me at X at Four Boxes Diner. We're closing in on 23,000 followers over there. And again, I thank you for your support, and I look forward to talking to all of you again very, very soon here at the Four Boxes Diner.
Orders up. Table 2A.